vi. Concerning the change of the corporate nationality. Like individuals, corporations are sometimes interested in changing their nationality. Can they do so? And in the affirmative, under what conditions? What are the results of this change? These are the questions to examine. It is now seasonable to test the ideas previously separated and relative to the determination of the nationality of corporations. If they are correct, the problem that we now approach will be easily and quickly solved. Exercising its activity, pursuing its aim upon the territory where it thinks, wills, and acts by its representatives, the corporation lives under the authority, the legislation, the jurisdiction of the state which rules this territory, and belongs thus to it by a lien of appurtenance and of dependence, real subjection. Its nationality is not, however, absolutely inseparable from its domicile, as those contend to confound the one with the other. It can, on the contrary, we have seen, be fixed by the founders, according to the situation of its principal center of exploitation. The logical consequence of these propositions is, on one hand, that the removal of the domicile of the corporation from one country into another, or the annexing of the territory which serves for the seat of this domicile, changes ipso facto its nationality to the profit of the state in the sovereign domain and under the protection of which it henceforth lives, and, on the other hand, that the same result is produced by a modification of the statutes connecting the corporation to the state upon whose territory its principal center of affairs is placed. Against this conclusion two objections are raised, drawn, one from the notion yet current of the judicial personality, the other from the spirit of different positive legislations, justified by the interest of the parties and that of third parties. The first can be expressed as follows. Artificial persons have their existence from the law under the benefit of which they have been founded and from this law alone. Without the provisions which create their personality in organizing it upon the plan of a fictitious life and sustain it thus in each of its manifestations, they are a pure nothing. If, then, one of them claims to escape from it to enter into the domain of another legislation, this can be only at the price of its existence. It is necessary first that it enter into nothingness from where the legislation it has preferred will summon it by a new fiat. More simply, a corporation desirous of changing its nationality must be dissolved and proceed to its liquidation and its distribution, after which the members will reorganize it in giving it a new nationality. Impossible, then, to conceive a change of nationality operated to the profit of one corporation there where it could concern only two successive corporations, the one recently dissolved, the other newly constituted, which pursue the same end in conditions analogous to which are submitted nearly the same members. The right of individuals to change their nationality is understood, for it results from the nature of things. The physical person has a life of his own, independent in itself of the political society to which the chance of birth has admitted him. But it could not be the same with the artificial person, fictitious creation of a certain legislation. If it breaks the lien that holds it to the law from which it has received its existence, it disappears. These metaphysical subtleties are the fruit of ideas more and more abandoned. Far from defining imaginary beings as pure legal fiction without rights or real obligations which the law establishes, modifies, suppresses, at the will of those who make it, now is seen the realities pre-existent to the law which has recognized and ruled them, manifestations of that human activity which the legislator could not disregard without injustice and which he ought by no means to consider as abandoned to his unrestrained will, influenced by the necessities, the political passions of those who have chosen him or those who inspire him. That which constitutes a corporation is a permanent substance on which positive laws impress such or such form. It can then be conceived that without ceasing to be itself it can take a new form, change its judicial attributes and its personal statute, in a word, throw off its nationality for putting on a new one. Could there exist in positive law any provision opposed to the exercise of this power? It is upon this ground the second objection is founded. When, one may say, the different positive legislations rule the constitution, the operation, the dissolution of corporations, they regard only the case of a corporation which may be founded, and not that of a corporation already organized, conformably to the provisions of a foreign law from which its members are desirous of withdrawing it. In this respect there is nothing comparable to naturalization, and one can only felicitate himself thereupon. What, indeed, signifies this change of nationality which is supposed to be permissive? Simply that the corporation continues to enjoy its personality such as its preceding domestic law has established it, the judicial form and personal statute which proceed from it in profiting from the time of its denaturalization, by its new personal law. It is thus that it could validly operate in France with a partially subscribed capital, divided into shares below the minimum legal rate without having had its shares of capital duly verified. In presenting itself as French and in acting in this quality. Is such a claim admissible? Can one conceive of many kinds of domestic corporations different by their respective personal statute? Some, those which have originally acquired this right to which the domestic law is applied absolutely and in all its rigor, the others those which have obtained it by a simple transfer of the social domicile and which have thus more or less completely avoided the most annoying provisions of this law of which, however, they invoke the benefit. This inequitable, strange, but very logical result of the change of the social nationality justifies the silence of the different positive legislations in respect to this combination not less than the interest of third parties who have dealt with the corporation upon the faith of its primitive personal statute. These could not suffer by a change in the situation which they have anticipated. They ought not to be opposed by a change of jurisdiction, of conditions of liquidation or of division, a prescription other than that which they had foreseen at the moment of contracting. Yet, again, the corporation is a contractual relation. When a nationality is assigned to this abstraction, convenient terms are used to designate the ensemble of the legal imperative or supplementary provisions which rule this contract and its effects. The accord of wills once established, its result could not be modified by one of them. A new legislation could not be substituted for that of the contract, for this would be to substitute a new corporation for the old one. This second objection supposes a persistency of the primitive social law, perhaps exaggerated, whose legitimacy we will discuss at the proper time. In every case it proves too much in order to prove what it is. The result which it condemns is indeed not more inadmissible than the greater part of the rules of private international law. This part of judicial science is based upon the respect of acquired rights in the domain of a foreign law. This grand principle of respect for acquired rights often occasions the concurrence of many legislations and thus obliges the judge to validate acts prohibited by the law of the territory upon which he distributes justice, and to recognize institutions less rigorous than those established by this law. It is that which is produced here. The rights acquired by the corporation under the empire of its original nationality are maintained to it without this survival hindering it from profiting by the advantages which result from its new nationality. Nothing more natural. The laws have no retroactive effect, as all that which the corporation or its founders had accomplished under the benefit of the provisions of the law to which it was previously submitted must be secured to it by the new one. In order to be able to declare, as one does, this solution absurd and anti-judicial, it would be necessary to have some other argument than the silence of positive legislations. The same absence of provisions is remarked on the subject of almost all the customary international rules, whose existence is nevertheless not in doubt. Let no one speak further of the right of third parties and of the immutability of the corporate contract. Here yet one would prove too much. We shall see a little further on what is to be thought of this last consideration. As for the first, it might be as properly invoked for declaring unopposable to third parties either the transfer of the domicile of an individual from one country to another, or even the change of a personal statute consequence of a naturalization. It is evident that these acts, manifestations of an incontestable right, are effective in the future erga omnes and that the creditors have only themselves to blame if they have relied upon the faith of their debtor, individual or corporate. These objections of principle laid aside, it is fitting to ask oneself under what conditions is subordinated the substitution, by a modification in the statutes of the corporation already constituted, of the nationality from the center of affairs to that of the social domicile, or the transfer of this domicile from one country into another, both of which facts produce this change. The realization of this change seriously modifies the condition of things whose consideration by the members at the moment of their entrance into the corporation ought to have determined this adhesion. Can it be imposed on certain ones among them? In the case of a partnership or a limited partnership with dormant partners it would certainly be necessary, in the silence of the statutes on this subject, to have the unanimity of the members severally and jointly liable, since all enjoy, save by contrary partnership articles, equal powers and each of them has the right to act on account of the company and to oppose an act of this kind made by his associates. Ought unanimity to be yet required of the associates severally liable to the amount of their shares of the capital? The general rule for all corporations is that the statutes can be modified only by the unanimity of the associates, for all have consented to the fundamental parts in the meaning which has been given to them. They have not consented to any other thing and cannot be obliged to any other thing without their consent. The majority could suffer only if the modification has been authorized by the statutes under these conditions. It is conceived that there was not then in substance a modification in the first agreement, but rather an application of this in one of its special provisions. And yet it would be necessary that the modification might not have affected the essential foundations of the corporation or, indeed, that this modification might have made the subject matter of an express and formal mention of the statutes. This opinion, strict deduction from the judicial principle expressed in Article 1134 of the Civil Code and sustained by some eminent writers, has inspired jurisprudence until a recent date. For some years a solution more conformable at once to the necessities of practical life and to the real will of the parties seems to have prevailed. The tribunes distinguish the modifications which affect the essence of the company from those relative only to its accidental elements. The essential parts of the social act ought to be observed, affirms Advocate General Homer. But what is to be understood by this expression? The learned magistrate enumerates the raisons d'etre of the contract of the shareholders relative to the object or the cause of this contract: aim, duration of the corporation, payment of the capital, distribution of profits. Since then jurisprudence has always tended to give to this formula and its synonyms a less restricted meaning. It is thus that it validates and presents the increase or decrease of social capital consented to by the meeting of the shareholders. Without entering into the examination of this problem, let it suffice me to recall the magisterial and truly decisive solution given to it by M. Thaler. The corporation, represented by its different organs, notably by the meeting of shareholders, exists, not only in respect to third parties, but also relatively to the members. M. Thaler has thrown upon this interior aspect of the social personality a vivid light, thus dissipating the obscurity in the shade of which the statutes are likened to an ordinary contract. Indeed, the dissenting majority of the shareholders ought to yield to the decisions of the corporations represented by the majority of the meeting, this not being a simple juxtaposition of members, but a real organ, animated by a corporate existence. Once established that this kind of assembly in which the shareholders are absorbed can modify the statutes, even in the absence of any clause of these authorizing this change, it follows that this power is not unlimited. What are its limitations? Are they opposed to the validity of this transfer of the social seat not unanimously consented to? First and foremost, in ratifying in advance, at the time of their entering into the corporation, the decisions of the general meeting, the shareholders have in no wise intended to make a complete abandonment of their rights, but have naturally reserved those which the social contract could not disregard without being reversible. The deliberations leave such rights untouched. Moreover, the statutory clauses truly essential could not be effected whose change would cause a modification of the object or the judicial type of the corporation, which would thus lose its identity in becoming a new corporation. If, as I think, these deductions are correct, the transfer of the social seat abroad does not necessitate the unanimous consent of the members, but only that of the majority requisite for modifying the statutes. There will result, it is true, from this transfer to the corporation a change of nationality and personal law, in other terms, different conditions of operation, but not a loss of identity, the consequence of a transfer of its personality being given at least the community of principles which reconciles the provisions of the different legislations on this subject. This solution offers no difficulty when applied to a denationalization, consequence of a transfer compelled by needs of the business. Such was the case in the two most recent examples relative to which the question of social denationalization was brought before the tribunals. In the first, a company of coal mines had transferred its domicile from France to Belgium, where the mine, object of exploitation, was situated. In the second, a company organized for exploiting tombak, essentially a Turkish product, whose monopoly had been secured to it by the Ottoman government, had equally decided to transfer its seat to Constantinople. The interests of the company, well or poorly understood from a business point of view, had, without doubt, in both of these cases, been the reason of these decisions. But let us suppose that they might have been moved by the sole desire of changing the social personal statute, for example, with a view of enlarging the powers of the administrators or of issuing some bonds according to less severe conditions. Could not such a decision, inspired by such motives, be declared fraudulent and consequently void? This question has already been elucidated at two attempts relative to the choice of a social domicile made by the founders and of their power to determine the nationality of the corporation according to the situation of its center of affairs. It is therefore useless to now reproduce the arguments then developed. Let it suffice to recall that there will to change the personal statute of the corporation, in realizing the desired conditions in order to acquire a new nationality, is simply the exercise of a right. The corporation imagines that it would more easily attain its object if it was ruled by a new personal law. Its representatives realize therefore the desired conditions that it may acquire a new nationality and by the same stroke a new personal statute. What more legitimate? There would be fraud only if the corporation simulated the transfer of its domicile to the foreign country or adopted the nationality of a country in the supposing a center of exploitation that did not there exist. Denationalization once effected, following the conditions which have just been indicated, confers on the corporation all the rights and imposes on it all the obligations of its new nationality. This idea is easily realized when it is a question of applying to the corporation the rules of its new legislation which affect in no respect its condition, its capacity, its acts in the past, or the future effects of its organic agreement. It is thus that it will be henceforth justifiable before the tribunals and will contribute to the taxes under the same conditions as other domestic corporations. The difficulty begins when the measure is sought according to which its condition and capacity are modified by the denationalization. Note: the following are the rules governing the formation of French companies, corporations. The Company Act can be authentic, or privately signed, and in the last case it is sufficient that it be drawn up in two originals, one annexed to the declaration that the founders have to make before a notary previous to the constitution of the company, the other deposited at its social seat, headquarters. In order that the company be legally constituted, the following condition must be observed. 1. The minimum par value of each share must be 100 francs if the capital exceeds 200,000 francs, and 25 francs in other cases. 2. The capital must be entirely subscribed. The subscriptions must be real and unconditional. 3. Shares of 100 francs must have a quarter of each paid in. Shares of 25 francs must be wholly paid in. 4. The founders must declare before notaries that the whole subscription has taken place and that the shares are paid in according to the law. To this declaration must be annexed one of the original acts of corporation privately signed, or a copy of the act that has been drawn up by a notary other than the one who received the declaration. 5. The meeting of shareholders must examine if this declaration is correct. 6. When there are shares of capital in specie or stipulations of peculiar advantages, the value of these shares of capital or the stipulations must be approved by the general meeting of the shareholders. If not, the corporation remains without effect. Those who have made these shares of capital or those to whom the profit of these stipulations have been made can vote. 7. A general meeting must nominate one or more administrators. 8. It is necessary that one or more commissioners of general supervision should be chosen for the first year. 9. The members or shareholders must be at least 7 W.E.S. There could evidently be no question of affecting acts made under the control of the former legislation, the new having no retroactive effect. There is no more question, after having respected the personal statute of the corporation in its manifestations before the denationalization, of obliging this to radically transform this statute in order to render it in all points conformable to the provisions of the actual domestic law, substituting thus a new corporation for the old one and disregarding all the conditions to which the members have subordinated their entry into this last one. The question is to know if the organization of the corporation ought not to be modified upon certain points, if the formalities complied with according to the former law for assuring the validity of its constitution ought not be renewed at least partially, if, finally, the social act can continue to produce, however indistinctly, all its effects, even those which are contrary to the imperative or prohibitive rules of the law by which the corporation is ruled. It is extremely complex. For answering it in a satisfactory way, let us take an example and suppose a joint stock company whose administrative seat is in England, while its center of exploitation is in France. This company is English, but it complies with the necessary conditions to become French. It takes advantage, then, of this power and introduces into its statutes a clause expressing this option. In this respect the English law is extremely liberal. It neither requires the whole subscription, nor the payment of a quarter, at least unto the amount of 25 francs, nor the division of the capital into shares of a minimum sum, nor the verification by a general meeting of the shares of capital in specie and particular advantages, nor the nomination of a council of supervision, all obligations imposed by French law, under penalty of nullity. It is satisfied with the registration at certain public offices of the statutes and a memorandum signed by at least 7 associates. It might be said, it is even the idea which is at first brought to the mind, that the French law ought not to be applied retroactively, and that there is an acquired right for the company to remain organized, to continue its function, and even to be dissolved according to its original law, because the acts accomplished under the empire of a legislation are, in principle, valid before the jurisdictions of all countries, rule that expresses very clearly the adage locus regit actum. It would be, then, according to the primitive social law that the validity of all the facts relative to the company ought to continue to be appreciated and that these should still produce their consequences. On consideration, this solution appears unacceptable. Among these prescriptions many have been imperatively imposed on companies which function in France, because the French law has found them necessary in the social, economical, judicial conditions of this country, of the kind that their raison d'etre exists by the single fact that a company is French. It remains to know which of these prescriptions pertain to the public order. I have the impression that the former English company must conform, within 15 days after its denationalization, to the formalities provided by Articles 55 and following of the law of July 24, 1867, excepting that which pertains to the shares of capital in specie and stipulated advantages, these not having to be verified. As can be seen, these measures of publicity are prescribed relatively to all French companies without distinction, and their raison d'etre exists just as well when the company has realized, after its organization, the conditions required that it may become French as when it is born provided with this nationality. I will say as much of the subscription of the whole and of the payment of a certain proportion of the social capital. There can, however, be some doubt on these 2 points. Have not these rules been exclusively imposed in the interest of the subscribers, and the subscription having taken place in the domain of a foreign law, ought it not always to be held as validly done in the result? It is the contrary that seems true. The exigencies of public credit which have prompted such provisions survive to the subscription. Would it be admissible that third parties who have dealt with the company on the faith of guarantees established by the French law should be opposed by a foreign law whose previous applicability they might have legitimately been ignorant of? The organization of a council of supervision is imposed for the same reason. It is besides very easy and is not susceptible of any serious inconvenience. It is otherwise with the verification of the shares of capital in specie and the minimum sum of the titles. The raison d'etre of these rules is the protection of the parties to the organic act, the maintenance of the regularity and honesty of their agreement. The protection of the capital of the place of subscription comes only in the second rank, also the titles in question if they are admitted to circulate in the countries which oblige domestic companies to be organized with titles of a higher minimum rate. It is to say that it is no wise necessary to impose on the corporation revision of shares of capital in specie issued, perhaps, since a long time from its funds and a decrease of the number of these titles combined with the raising of their sum, measures very difficult to be realized and probably more disadvantageous than useful. Thus completed and reorganized under this somewhat hybrid form, the former English company will enjoy the capacity that its new personal law confers on it. It is according to this law that will be measured from its denationalization the powers and the responsibility of administrators, agents, liquidators. However, these last will be obliged, evidently, in the silence or the insufficiency of the statutes, to follow the rules of division contained in the legislation to which the corporation was submitted at the moment of its organization. These are only the forms and the procedure of the dissolution, of the liquidation, and of the partition which will be determined by the new law.